The urgent applications were brought while NDP Maniati was still engaging with the applicant to hand over the applicant at a police station for processing in preparation for the enrollment of the matter. It is common cause that even before this application before me was brought, it was indicated to the applicant that the respondents would not oppose bail. An arrest on its own cannot create urgency, especially when there is no apprehension of detention. The applicant herself concedes it was brought to her attention that resort to Section 40 of the CPA would be the last resort. This fact is now, however, used as to create urgency, despite it being a last resort. Furthermore, whether there is a weak case is speculative, and the court should not consider this as a ground for urgency. The media leaks by the NDPP are denied and also do not constitute grounds for urgency. There has been non-compliance with the practice directives as to service and the date it was enrolled. One cannot anticipate another urgent application. Ruling on urgency. It is trite that an urgent application is not for the mere asking. Rule 6 in brackets 12 in brackets B sets out, and I quote, "In an urgent application, an applicant must set out forth explicitly the circumstances which averred rendered the matter urgent and the reasons why the applicant claims that the applicant would not be afforded redress at a hearing in due course." The locus classicus of Luna Meubelvervaardigers Edensburg Park versus Macon and another, trading as making furniture manufacturers, 1977 4 SA 135W bears repeating. I quote, "The degree of relaxation should not be greater than the necessity of the urgency that the case demands. It must be commensurate therewith. Mere lip service to the requirements of Rule 6 in brackets 12B will not do, and an applicant must make out a case in the founding affidavit to justify the particular extent of the departure from the norm which is involved in the time and day for which the matter must be set down." I close the quote. The Gauteng Pretoria Practice Manual, contained in Volume 3 of Erasmus, sets out how urgent applications must be brought before court. On page H2/137 in bracket 6, it reads as follows. "The rules ensures an orderly flow of applications to the court and their expeditious adjudication. Rule 612 allows an applicant who requires relief urgently to have his case decided without the delays necessitated by the ordinary procedure. However, the normal times will be abridged and the deviation from Rule 6 will be permitted only when the matter is urgent. The degree of abridgment and deviation must be commensurate with the case and must be justified in the founding affidavit." On page H2139, under 4 brackets 2, the following is said. "The abridgment of times and the deviation from a rule must be justified. If the matter is not heard immediately, the applicant will not be afforded substantial redress, and both these matters must be pertinently dealt with in the affidavits filed in support of this application." The court has to decide whether the matter is so urgent that the timelines are justified and the urgency is not self-created, because, I quote, "Where the application lacks the requisite element or degree of urgency, the court can for that reason decline to exercise its power under Rule 612B. The matter is then not properly on the court's roll, and it can decline to hear it. The appropriate order is generally to strike the application from the roll." And I quote from Commissioner for South African Revenue Services versus Hawker Air Services Pty Limited, Commissioner for South African Revenue Service versus Hawker Aviation Services Partnership and others, 2006, in brackets 4, SA 292 SCA. the Constitutional Court in a party and another versus Minister of Home Affairs in another, Maloko and others versus Minister of Home Affairs in another, 2009-3, SA 649CC at paragraph 65, found that launching applications on such short notice and at the very latest date should be avoided, as it places undue pressure on the parties and the court. In Economic Freedom Fighters and others versus Chairperson of the Powers of Privileges Committee and others, 2024 ZAWCHC 31, dated 8 February 2024, it was found that one day notice to the respondents with the court, and I quote, to digest the contents thereof so that the matter could be heard and judgment handed down in the space of 1 day or 2 thereafter was wholly unreasonable. With that background, the court has to decide this urgency. In this matter, the application was filed on a Saturday. The respondent was to oppose the matter by email or extraordinarily by means of WhatsApp on the Sunday by 1600 hours on the same day, Saturday, the 23rd of March 2024, and to deliver any opposing affidavit by no later than 1600 hours on Sunday, 24 March 2024, with the matter set down for Monday, 25 March 2024. The court was expected to hear this matter on Monday at 10 o'clock. The respondent's answering affidavit was filed on Monday, and the matter stood down till 1500 hours for the applicant to decide whether it was to reply, for the court to have time to read the answering affidavit in between the other 20 urgent applications this court had on its roll. The court managed to read the answering affidavit and entertain the matter at 1500 hours. The applicant had decided not to file a reply. It is patently clear that none of the practice directives of this court was adhered to. The time frames in terms of Rule 612 were unreasonable, not only to the respondents, but to the court. It was argued that despite these shortcomings, the urgency is so patent as it stems from the threat to arrest the applicant without a due and lawful process. And the whole premise of the applicant's case is 1, the applicant standing in society, 2, there is an unlawful prosecution, 3, the arrest will be unlawful, and 4, the applicant's constitutional right to dignity and freedom of movement will be infringed. Arrest is a means to process a suspect and have an appearance before court. The respondent set this out in the answering affidavit, but it is trite. The applicant, by means of her attorney, sets out in the main application prior to this application that the NDDP does not even intend to oppose bail. This was already in the main application set out, making it clear that detention was not an issue. In the answering affidavit to this application, the NDDP confirms that it will not oppose bail. Arrest without detention simply is not urgent. It is most certainly not within the power of this court to instruct the minister and his officials to summons the applicant versus to arrest her. There is in any way no such prayer sought in the application before me. I cannot find this, firstly because there are no grounds set out as to why this should be done, except that the applicant's standing in society and her dignity. The NDPP has stated under oath that her attorney can take her to the Littleton police station and the attorney can take her to the court. This is already a courtesy and an exception to what ordinary citizens are afforded. There is not a single fact set out as why to the future arrest will be unlawful, seemingly because there is a weak case made out. Yet the applicant does not know what case has been set out, and this is pure speculation. I can make no finding on such speculation that there will be an unlawful arrest. or that there is a weak case. These facts cannot underpin urgency. The respondents argued that it would not be competent for this court to interdict an arrest. I'm in full agreement with this submission. Not on the facts presented, but more importantly, a court has to take cognizance of the fact that if the court grants such an order, the floodgates will be opened. Every suspect will be in a position to approach a court on an urgent basis, setting out on speculation that there is a weak case against it and interdict an arrest. Any suspect would merely have to set out in a founding affidavit that an arrest in future will be unlawful. The whole criminal justice system will fail and will be controlled by suspects. This applicant has been ensured that Section 40 will only be utilized if she does not present herself to the police station. The applicant has failed to do so for 2 weeks. The fact that Section 40 will only be utilized if she does not present her to the police station is in complete compliance with the standing orders, which sets out that arrest should be a last resort. I was referred to the matter of President of the Republic of South Africa versus Zuma and others, 2023, 11 SACR 610, Gauteng Division, paragraphs 8 to 10, that it would not be an overreach for this court to interdict arrest, but a bench exercising judicial oversight, if I should interdict the arrest. The matter is not comparable and does not sway me that I'm entitled to judicial oversight of this nature. Firstly, nowhere in that matter does the court find a court has judicial oversight to interdict an arrest. Second, in that matter, the summons was before court, and a plethora of grounds regarding its validity on the face thereof was raised. In this matter, no arrest has been made, and no unlawfulness on its own has been explained to court, excepting for pure speculation being raised. Furthermore, the court in that matter found that National Treasury and others versus Opposition to Tolling Alliance 2012 in brackets 6 SA 223 CC was not applicable in that matter due to it being a private prosecution. The OTA case had held that where it sought for an interdict for a statutory authority from performing a function within its remit, a higher threshold existed than when seeking such relief against a private litigant, as in this instance. Much reliance was placed on the fact that the applicant has a right to legal representation of her choice. Clearly, the NDPP and the police investigator is aware of this right and has afforded her ample time to report to the Little Police Station with a legal representative. Mr. Perumal, already on 9 March 2024, had asked who her legal representative is. On 17 March 2024, the legal representative for the first time made contact with Perumal. The delay in processing the applicant was done out of courtesy. It was made clear that it was not a negotiation and was not open-ended. Mr. Meyer set out that due to a long trial in Durban, he is only available on 3 April 2024. I was referred to Section 35 of the Constitution and Section 73 of the CPA. Firstly, all of those sections refer to an accused or an arrest or a detained person, which are no construction this applicant before the court is. But, accepting that pre-arrest, there is for informational duties in terms of Section 73 2A, with these duties arising at the time of the arrest of the accused is entitled to legal representation. This right does not include that a legal representative dictate when a police official acting in terms of its authority has to fulfill its duties. The averment that the respondents don't want an attorney present for her to incriminate herself is pure speculation and flies in the face of Paramore and the NDPP attempting to secure an attorney to be present at her arrest. Already at the gatehouse, the applicant is afforded legal representation. She has been afforded a right to legal representation in the pre-trial and pre-arrest stage. A court cannot interdict to prevent statutory authorities to comply with their statutory duties. And it is not as if the state representatives have been not lenient and has let 2 weeks go by. The prayer that I take judicial pick is for the court to determine whether an arrest would be unlawful. In reply on behalf of the applicant, pursuant to a question by this court, it was submitted that I only need to take a peek into the docket if I'm uncertain. I'm not uncertain, and I exercise my discretion not to take a judicial peek. This court is not a means to declare an arrest which has not taken place unlawful, or that it would be unlawful, or express a view thereon. I am therefore also not granting this order. Although I do not address all the issues raised, it does not mean I did not consider it. No remedy is pertaining to the search and seizure. The respondents deny the media leaks emanate from their officers or agents, but in any event, no remedy is sought pertaining to any leaks. In the applicant's affidavit, there are a variety of emotive garnishing, on which a court unfortunately cannot take cognizance and make factual decisions on that. However, even if the court finds that the matter is not urgent, the court must still make sure that there is substantial redress in a hearing in due course. Not in the founding affidavit of this application or in the main application is any fact set out. This requisite in terms of Rule 612B and the Practice Directive is not at all addressed in the founding affidavit. But even if I consider it, despite the applicant setting out any of these facts before me, even if I should consider it, then also pursuant to a question by this court, whether this court would not be deciding already the matter as it seeks the same relief pertaining to arrest in the main application, counsel for the applicant strongly argued that that court would make a final ruling, as this is just an interdict. In that case, the applicant will have substantial redress in a hearing to follow. As for the cost must follow the result. Both parties asked for costs, including the costs of two counsel. According, the application is struck from the roll. The applicant is to pay the costs, including the costs of two counsel. The court will adjourn.